want to talk about generally estate claims, and maybe Suzana, you could start with some of the common aspects of estate claims that we're seeing more and more.
Sure. There's, I would say, more or less four main categories that we see on a daily basis. And one is claims for debts. So if the estate is going to be making a claim for money that is owed to the deceased, or vice versa, people are going to sue the estate for money that was owed by the deceased. We see those kinds of cases quite often. Constructive and resulting trusts are arising quite frequently as well. And we've got, of course, the dependent support applications and claims for dependents who haven't been properly or adequately provided for by a deceased, bringing claims to try to enhance their entitlement from the estate. And of course, the family law equalizations by married spouses at the end of the day. So those are the main ones that we see for the most part. There's, of course, other ones like, seeking a repayment of a loan that was made perhaps by a child or by a third party to the estate. And so those are the categories that we're seeing quite regularly.
So let's just break that down a little bit, because, of course, the common claims that we've described are out there that challenges the will itself could be included, but that you've described. But the common claims that we see within it, and you can only draft so much to protect the first set. But the repayment of loans, as you're saying, claims for debts, and even constructive trust and resulting trust claims. Jordy, you see these claims percolating at the point of instructions all the time, and there are certainly ways to protect around this and to get ahead of it, so to speak, at the drafting stage, aren't there?
Well, I mean, certainly identifying the payments of loans, not appointing executors who owe money to the estate, and putting them in a conflict, avoiding conflicts. Those kinds of conflicts are important. Resulting trust claims and constructive trust claims, they're hard to deal with. I mean, somewhat, in some cases, you might have to draft around them and say, listen, in the event that this person brings a constructive trust claim and actually owns certain of the assets that I'm proposing to deal with, they're going to get less. I mean, imagine that, like that we've actually had some experience in, and it's very difficult. If you anticipate one of the beneficiaries actually having a constructive trust claim,